Well,
Yes, yes, please.
okay. So
We welcome on behalf of the Vidya Vijay Foundation.
it's my pleasure, sir. It's my pleasure.
Please. Thank you.
So I think host needs to enable the screen sharing. I'm not able to share.
Just miss. Just.
Thank you. Thanks.
How? Sorry, it is allowed.
Yeah, thank you. Thank you very much. So I hope my presentation is visual to everyone and I'm audible as well.
Yes, sir. Yes, sir. Please.
Thank you. Let's start. So drafting of agreement. This is required. I mean, agreement is like we do it in our personal life as well as professional life as well. So here we will be talking about in a business sense, how a commercial contract or business contract is drafting. So when we will be company secretary, we will be joining either as a, in some corporate, or we will be going for our individual practice. We will come across various agreement where either we will be making the agreements or we will be reviewing or, analyzing the agreements. So generally we call it, sometimes we call it agreement, sometimes we call it contract. I won't go into that definition, because that's a basic which we all have been taught, during our curriculum and course, whatever we have taken, whether law or CS and so on. So why contract? हमें क्यों contract की जरूरत है basically? So because in modern business days, various deals are through contract only. Contract can be like for running day-to-day businesses of the company, be it a manufacturing or a service provider, or contracts can be on like for acquisition, merger, and so on. This contract is required to ensure what are various deliverables of the parties. There can be multiple parties to a contract. To begin with, two party at least required. So what are the promises? What are the deliverables? What are the commercials? Because human memory is short. Law of contract nowhere says that the contract has to be into black and white, I mean, right in written. But for the ease of convenience, for future reference, because for I work in a company and today I enter into a verbal contract. I'm just giving an example. And tomorrow I switched, then memory with me only. That's the reason we are it is preferred to have a contract in black and white, so that it can act as a reference in future, and it can help to understand what are the various liabilities, responsibilities, deliverables of the parties, to bring certainty to the thing. Otherwise there can be n number of litigations. Besides, there are certain requirement under accounting standards and so on, where no one will buy this idea of that contract can be a verbal. They only ask for a written document. So we have discussed this. I mean, the purpose is to have a clear contract is nothing but a marriage of convenience. When two parties exploring some kind of business relationship and they want to move ahead with their business transaction, they prefer to have a contract in place where everything is written in with clarity, without any confusion, and so on. So what is a contract? How much law is required? Law, very little law is required. What is more required is to have a clear drafting, so that even a third person who was not a party to the contract can understand by reading the plain English. So we always emphasize that if you have a good English, good grammar, good vocabulary, then you can make a good contract. We discussed this. And now there can be various contracts which we enter, as I said earlier, into our day-to-day life as well as professional life as well. It can be like if you take a building on rent, it can be leased for office purpose or use as a residence. Then there can be certain high value transactions where M&A, merger and acquisition, may be contemplated. So we can have some kind of NDA before entering into a transaction a separate NDA agreement, because the party will be disclosing certain informations which are very confidential into nature, which may harm if disclosed to the public. And there can employment, when we take some employment again, so there is a contract between employer employee, and business contract all there. Even when as an individual practitioner, a person takes a client, it's a sort of contract only, but generally they are all verbal understanding, except when there are big corporates, and on the other side there are some consultants, or they insist on writing. So these are the few essentials of a contract. What are the various essentials which a good contract should contain? Like, first of all, I'm switching off my video for better this thing. First of all, we need to define the parties. And this is more important to know the parties who are entering into a contract, because nowadays we are listening about ED, money laundering, so on. So to have a clear understanding of the party with whom you are entering into a arrangement, agreement. Then recital. Recital is a summary. Per se, recital is not legally binding. It has to be read along with the other clauses of the contract. And then definitions. If you are expecting certain definitions, which will certain words which will be used frequently in the contract, then it is advisable to have a definition clause and also interpretation clause, how things will be interpreted. Then scope of work, very important question, clause of the agreement. Scope of work basically defines what is expected from the parties to the contract. And obviously consideration, because to be a valid contract, you need to have consideration. Will come during our presentation on this clause. Then right and obligation of the parties need to be there. Confidentiality clause, what will be the term of the contract. And the one important thing is boilerplate clause. So contract is a collective effort. It's not like general tendency is like
तुमच्याकडे एक्स्ट्रा सोनोग्राफीज होते फक्त इसको वगैरे नाही.
request all the participants to be on mute. Request everybody to be on mute except if you are speaking regarding this session. Thank you.
Mr. Karke, please mute. Vivek. Yes, sir. Please go ahead.
Okay, thank you. So agreement is a collective effort between, if I talk about a company where an agreement is to be drafted, then agreement is a collective effort. It's not like legal can make the contract, because legal can only put it into a legal framework, but a contract certainly carries certain clauses.
अभी तो दिल्ली दूर है मतलब. ऑनलाइन पेमेंट.
So host, can you please put everybody on mute except the presenter? So every contract will certainly contain certain legal clauses like jurisdiction, assignment, force majeure, indemnity clause, limitation of liability, and so on. Rest of the clauses like scope of work has to be provided by the department for whom the contract is being made. Service level or quality, or you can say deliverable will also to be provided, so on. So that's why I say the contract is a collective effort between various functions, between various people. Now this is the basically the definitions contained in contract, like what is a contract. If agreement is enforceable, then only it is a contract, and otherwise it's not a contract. agreement consists of certain set of give and take, like promises, then offer should be there, then there should be acceptance. Now, coming to what is a valid contract? So there is a definition, there is a requirement under the Indian Contract Act. So what are the essential requirements? It's like competence. Party should be competent to enter into a contract. What is the competence? It has been defined, like person should be of major age, sound mind, this, and so on. Then it should be for a lawful consideration. Object should be lawful. It can't be like one enters into an arrangement with somebody that you will murder him, I will pay you certain amount. It's illegal, so it's not a contract. Though there is a offer and acceptance, but one of the essentials of lawful contract is missing. Then free consent. It can't be like somebody put a gun on my head and say sign this contract. Then it's not. Free consent is missing. So here I would like to apprise everybody that there are certain relations which have been assumed by the law where consent is not free. Parent-child relation. तो मेरी माँ है, ये बात भी नहीं मानेगा मेरी, तो वहां पे consent is not free. Similarly, employer-employee, because parties are not at level playing field. Employer is always having a upper hand, and especially in a country like India where there is so much unemployment. Agreement offer letter पे कुछ भी sign हो जाता है, but there the consent is not free.
750 ना?
Master servant.
Yeah.
If there is a fraud, undue influence, parties. What happened?
I request Mr. Kakade. I request Mr. Kakade, if it is audible, please mute yourself.
What about it?
My presentation visible or not? Hello.
Well, right now.
Sir, it's visible for presentation?
No, sir, not right now.
Okay, let me reshare. Don't worry. Just a minute. Nityanand ji, I'm
Ji,
not
ji,
able
please.
to share again the same message for disabled participants screen sharing.
Just a minute.
No, you can share, sir.
Okay, fine. Thank you. Yeah.
Yes, it is visible now.
Thank you. So as I said that we have to be very clear that we have, while drafting a contract, we have to be very, very careful about the English what we are written. Otherwise, prostitution. I think I would you would be able to recall that movie Jolly LLB, the first one.
Yes, sir, please.
So English has to be very, otherwise appeal is apple. That is a perfect example. So we have to be very careful on our English and drafting it proper. Otherwise, it may give some unintended results which are not expected from a contract. There is no need to write in British era English and here to until undo and that make things complicated. So we have to be very clear, precise English, small sentences, so that anyone can understand and which is not subject to interpretation. Simple English, simple meaning, that's it. very specific, because whatever we do, whatever we want to achieve through a contract, there is a purpose to it. So we have to be specific. No vague term should be used, which may result if there is some dispute, so which may be subject to different interpretations. Wherever required, even an example can also be given, or further things can be clarified in the contract. Because there is a English proverb that devils lies in the details. As we go in detail, we are into a better position to avoid any kind of confusion. So contract, it's like give and take. There are two parties to a contract, and it's very unlikely that both parties will be at level playing field. One will always be in a position to dominate the other. If I talk about like an automobile, if you are entering, you have been decided by Maruti or Honda to supply certain products. Definitely you are a supplier, and Maruti and Honda, they are at, a position where they can dominate. But here also you have to see what are my, कहाँ पे give and take, कहाँ तक करना है. I mean, what is my limitations? I have to take contract, but it's not like you have to raise red flags as well, so that at least liabilities can be identified and they can be minimized. And you know where I have to say no. So now a very important slide. So before starting a contract, when you are approached for a contract, you need to devote sufficient time to understand the expectations from a contract, to understand the business for which the contract is to be drafted. And in case of corporate, there are certain approval metrics as well. Who is authorized for what, so that later it may not become a bone of contention or a region of dispute, that this was not authorized, the transaction was not authorized, and this person was not authorized to approve the commercials. Then in the entire life cycle of the contract, basically the legal department or the legal guy who is responsible for the drafting a contract has to work very closely with the concerned department. The concerned department, I mean to say, the department for whom the contract is being made, who is going to avail or deliver the services pursuant to that contract. Then identify where we are open for negotiation, what are our non-negotiable points. The point, it's like catch 56 situation where we can say no, this is a deal breaker. Nityanand sir, there again there is some problem. Again, I don't know what.
Vivek,
You again became the host. Yes.
Sir, you are, you can share, sir, now.
Hi, again. I hope audience will excuse us for this technical glitch.
we are extremely sorry for that.
It's okay, it's okay. I'm perfectly okay. So no problem with the audience, because that's the thing.
Yes, yes, please. Request to all the audience to bear with us, please. There is some technical issue. Please, sir, go ahead.
Yeah, thank you. So these are a few of the things which we need to keep in mind while making a contract, like commercials should be clear. Contract should follow the commercials, not otherwise. See, sometimes what happens is that commercial are decided, deal is closed, then one is approached for drafting a contract. It's like putting a engine behind a bogie rather than in front of bogie, railway bogies. So during the drafting of contract, various negotiations are held between the concerned department with opposite parties, with their teams. So we need to understand where we stand, uh, and what kind of negotiation we can do, how critical is the contract for us. uh, is it a business critical contract or is a normal routine of contract? By understanding all these things and understanding the business, one can decide how to negotiate, because that is very important, and you need to understand your position, where you stand vis-a-vis other party. Well, ultimately the business must go on, show must go on. Patience plays a very crucial role if you have time with you, because some in most of the negotiation what happens, let me give you a very good
Oh,
example. When in merger, who blinks first, he will lose negotiation, or he will be at a receiving end if blinks first. Patience is very important.
oh,
Miss Aishwarya, please mute yourself. Miss Aishwarya. Thank you. Sorry, sir, please go ahead.
Thank you. At the same time, it's not like to say okay, that though we say that parties may be unreasonable, we have to be in the interest of time and in the interest of business. We also need to try to close the contract as soon as possible, with fair and with being fair and reasonable. Never try to twist arm. Ultimately, if it is a win-win situation for all the parties involved in a contract, it's very good for everybody and it has a longevity. Otherwise, if the party is unfair, reasonable, like if you are into a dominating position and you have surplus material and you have dictated the term, the other party will soon find alternate. And we need to understand we are not into a monopoly market. If somehow through a contract, a negotiation has been done where the prices are more than reasonable, then what will happen? The receiver will enter into a contract with you, and parallelly he will be looking for some alternate. So all these things we need to keep in mind. So this is basically a life cycle of a contract, how a contract starts, how end. I mean, one more important thing is of the contract is like storage. We have to keep contract so that it can be retrieved, it can be it is available when required. So if we start with it, so first of all, there can be a request for a contract, then drafting, vetting, reviewing, taking approval, followed by execution. Then it's storage. There is a software also called document management system where you can put in, because renewal is also important. It's not, you should be aware when this contract is going to be renewed, going to be expired, so that we can proactively approach, I mean, whether it needs to be renewed or it needs to be terminated on the end of its time. And storage is also important from the perspective of audit, or it gives business if you keep all your contract in one place. From a business perspective, if there is some deal of acquisition or takeover, then contract goes a long way. So the responsibility of the legal department is to manage, not only is not limited to the execution, it's the management of entire life cycle of the contract. Confidentiality, one of the very important clause. Sometimes if there are large transactions, separate ND agreements are executed. Otherwise, what happens? There is a clause, confidentiality clause in the agreement itself, which talk about that the parties will be entering, will be sharing certain confidential information which are not to be disclosed, because they may result into certain liability if disclosed. Now, most debated clause is like liability, indemnity, and its enforcement.
चेंज है बात
So in an agreement, these are legal clauses, boilerplate clause, but we have to be very careful while drafting, because understanding of the importance of the transaction or purpose to be achieved through the particular contract can go a long way in deciding the liability, its limitations, indemnity, and so on. Because these clauses which are expected from a legal team, I said earlier that agreement is a collective effort, but these boiler clauses are to be reproduced by in a contract by a legal guy. So unless the importance of the transaction for which the contract is to be executed and the business is understood by, it's very difficult to produce a right clause. What is to be excluded? What is to be included in liability? What will be the restrictions on the liability side? Where I have to cap my liability? And generally that we exclude as a matter of practice all indirect consequential losses. But for direct, there has to be some cap. It can't be open-ended. And if you are on we can add a liquidated damages also. I mean, to fix the, if we see that the contract is important and if we may suffer a harm or damages because of the breach of other party, then we can put a an amount as liquidated damages. Because if that is not written, then it has to prove what is the damages, what is the amount of damage you have suffered. Damages there, you only have to prove that there is a breach of the contract. Another important clause, what will be the tenure of the contract? And if I enter into something, I need to know the exit as well. So term of period or term of the contract, or if I want to get out of it, suppose I entered into agreement with certain expectations which are not being met and I am frustrated with the contract, I want to come out. So we call it, like one of my dear friend always say, when it comes to marriage, everybody is dancing and enjoying, but advocate is always thinking what will happen if there is a divorce. And legal is about being pessimistic, nothing wrong. Sales is about being very positive and optimistic. But you see the finance guy, accounts guy, or a legal guy, they always about ye ho gaya to, and you will be, people will say that yaar ye tum to bahut hi negative, don't take it, don't give much attention, because it's all about being on the safer side than saying sorry. So when it comes to contract, you always need to have some sort of exit clause. If things are not going up to mark and I'm not further I want to terminate the relation, how I can do? 1 month, 2 months, 3 months. Like if there is a very critical contract, suppose call center is very critical for a telecom company. Then you have to see again understanding of the business requirement, purpose of the contract can go a long way in deciding the term, period of exit, notice period, we call it. Because if I decide to terminate a contract, how much time it will be required for me to find out a suitable partner? That is can act as a broad guideline for us. If I'm sure that I can find out a good replacement in 2 months, then it's advisable to have a
340. Request to all of the learned friends, please mute yourself. Yes, Mr. Prashant. Mr. Prashant, if I am audible, please mute yourself. Thank you. Mr. Yes.
And that termination can be for cause, like if this event will trigger, I will terminate. Like in a material supply contract, if the you fail to deliver the material on time, time is essential of a contract, or there are two default or default more than so many days, then I will terminate the contract. That is with cause. It can be without cause also. भाई मेरे को नहीं समझ आ रहा. बस we have decided to exit. So that can be without assigning any reason. So there can be two type of termination, with cause, without cause. And we can always add a timeline to it by 30 days, 60 days, depending upon business exigency, importance of the contract, how critical it is, and so on. Because future is always uncertain. You never know when things go change, and you may not be any interested due to technological change or something else, or some business plan had changed. So always have a exit. It may or may not be exercised, but it's always required or recommended to have a exit clause in place. Even if you have entered into a wrong contract, if exit clause is there, termination clause is there, you are saved to a certain extent. Not absolutely, but to a certain extent, you are saved. Your life is simple. Then jurisdiction. Because there is a possibility that there may be certain dispute with regarding to any of the clause or the contract as a whole. So which jurisdiction one needs to decide in the for that particular contract, which needs to be part of contract, and governing law as well. There is a lot of debate regarding this place will be the jurisdictional place, which court have. So nowadays alternative remedies are there. You can go for arbitration, or you can go for some court jurisdictions. If you have written something in the contract, then that will prevail over the general law. It is always advisable to have a neutral jurisdiction. Neutral means like a place where both the parties are not, doing business or residing. That is a called, like I am from Delhi, the other party is from Mumbai, I can have a Bangalore jurisdiction. Because I'm not agreeing for the jurisdiction where the other party is situated, and vice versa. The other party is also not agreeable to my jurisdiction. So we can have a neutral jurisdiction. If arbitration clause is there, so we have to be very careful. Like it has to be sole arbitrator, or it has to be panel. ऐसा ना हो कि नाच ना हो इतने घाघरा फट जाए. Like contract की what is the contract value? Because if there is a panel, then both party will decide, will choose one person as arbitrator, then these two will decide third, then fees of all these three, all these mathematics has to be kept in mind. So for international jurisdiction, Switzerland, Singapore is a very famous jurisdiction, which people agree because it has over a period of time developed as an international arbitration center. SIAC we call it, Singapore International Arbitration Center. Then which law, and if there is any dispute, then what will be the law that will govern. So these are all things where a person from legal side can contribute a lot. His expert come handy.
அப்படியா சூப்பர் அப்புறம்
Why arbitration is evolving? It's very fast. Cost wise also, because time is very important nowadays. In this fast moving world, time is very important. And commercial can this arbitration go a long way.
இது ஒரு
Request all the way.
Mr. Bishnu, please mute yourself.
வேற யாரு?
Mr. Bishnu, please.
ஒரு நிமிஷம் நான் திருப்பி கூப்பிடுறேன்.
Mr. Bishnu.
एक मिनट.
Please mute yourself.
Sorry.
And Mr. Vijay Kumar. Mr. Vijay Kumar, please also mute yourself. Thank you. Yes, sir, go ahead.
I need to make host.
Sure, sir, sure.
Thank you.
Of disturbance.
Not able to share the presentation.
Vivek,
Yes, sir. No, you can share.
Okay. So why arbitration as a medium to resolve disputes of contracts is becoming more and more, popular. Reason being very fast, cost effective as well. And the most beautiful thing about arbitration is that you can have a person of a related field or arbitrator who understands the nuances of the business. If that kind of person is appointed as arbitrator, it can help resolving the dispute in a more professional manner rather than a court. With due respect, I'm not disrespecting any court, but judges, they are from generic background, and if a tax matter involved issue is there, in comparison to a judge, a person appointed as arbitrator, if he is having a tax experience, then is always in a better position to make a more reasonable and seasonal judgment. Indemnity, one of the legal clause of the contract, and which is expected from an advocate, a company secretary also. We need to be very understood the indemnity, nuances of indemnity, vis-a-vis damages. There is a very thin line of difference. Sometimes we use both. So what will be the indemnity? Indemnity is basically to bring the position party in their original position. Most of the contracts will indemnity will find a place in most of the contracts. Indemnity, limitation of liability, damages, all can be part of a contract depending upon the importance of the contract. If damages is mentioned, then always try to mention the amount also. There is a difference between indemnity and damages. We have to be very clear about it while drafting these clauses of indemnity and limitation of liability. And always never agree for indirect losses in consequential damages, because it's very difficult to put a figure to it. Had this been done, I would have earned so much. So there is no end to all these hypothetical things. So contract once made, its parties are not astrologists. It's very difficult to see the future. If what will happen if we need to amend, if there is a need to modify certain things due to technological change, change in business environment, and so on. Modification. Yes, you can very well legally do a modification to a contract. So we can name it like modification, supplementary agreement, and so on. Basically, the word supplementary will be used when you are trying to supplement by adding something to an existing contract. Addendum, amendment is when you are making amendment to an existing clause. Like you are doing it for 4 services in a service contract. You want to add a 5th services to the contract because you are as the service of the party or the quality of service is very good and timely. So we will call it generally we will call it supplementary agreement. And if I want to amend the existing clause, like some deliverables and commercials, then we will call it addendum also. Yes, for any additional understanding, we need to mention that it's a supplementary agreement, which is supplementing the existing one. And amendment is basically to, if we want to delete some clause, we want to improvise upon some clause, then or substitute it. There are some tech tools available online as well for a contract, like time management, tracking of the contract, execution, deliverables, retrieval, and so on. So we need to use technology also while drafting our contract. But technology can't replace human minds. We have to be very clear about this fact. So it's all about from my side. Now, I would appreciate if there is any confusion, very difficult to cover everything, but I have tried to touch upon main points quickly. Any questions I would try to address?
Now request to all of you that you can switch on your videos, and if any query, then certainly Mr. Kishan, one of our learned friends, is able to answer that questions. Yes, please. Any of one of our friends? Any query? Sir,
Hello.
Yes, please.
Yeah, myself Manish Nehra.
Welcome.
I just want to ask, can you more elaborate about the arbitration clause? Like recently going on what are the amendments with respect to arbitration clause that we put in the contract act, contracts of a business in perspective of a business?
So arbitration, very relevant question you have asked, because nowadays the way the courts are work, say there is so many delays, and time is the money for a business, and we need to, whatever dispute is there, we need to settle in a time bound manner. Government is also doing its bit to make arbitration more popular. So while drafting an arbitration clause, it's always better to have a arbitration clause rather than a court jurisdiction, first of all. And the second thing, then how then arbitration clause is to be drafted, that is very important. Because as an now, instead of focusing on business, we are focusing on disputes, and we are because we are not we are here for business basically. So arbitration, like what is the value of contract, that has to be kept in mind, very important point, because that will help me to decide whether I should go for one arbitrator, or I should agree for a panel of arbitration. It has a cost element. Recently, there is some amendment that arbitration has to be concluded within 6 months, then it can be further extended by 6 months. These are all good initiatives, but practically very difficult. But if we are able to close a dispute within a year or so, also through arbitration, that's a good thing. So coming to again the point whether we should have a sole arbitrator or we have a panel, it's all depend upon the importance of the contract and the value of the contract. Okay. And the second thing is that arbitrator, who has to be appointed arbitrator, it is also very important, because here we have the flexibility to go for to select a person as arbitrator who understands that business. Suppose there is a automobile companies who are into a dispute and they want to refer to and you are a legal counsel over there and you want to appoint some arbitrator. So it's always advisable and good to have a person who has a good amount of automobile experience. So he can better understand the industry and can give a better decision judgment. Earlier, what used to be happen, like any of the party who is at, in a position to dominate the contract will say that I will appoint a sole arbiter. That law is no more, that clause is no more legal. Now it has to be mutually decided. So I don't think that if you appoint a person with similar industry background, then other party will oppose. As a person, they can oppose here, but it's a very fair thing that you should go for that kind of background. rather than a plain, judge with a generic background. And then place of arbitration, because it has a cost involved. So all these things has to be kept in mind and can help a lot in drafting a good arbitration clause. I hope I am able to answer your query, or still you have.
Yes. Thank you. Thank you so much. Thank you so much. It's more clear now.
Yes, anyone else, please? Sir, one question in my mind. Suppose if nowadays the Supreme Court has passed, Honorable Supreme Court has passed another that sole arbitrator is no more valid arbitration agreement clauses in the agreement, because most of the financial institutions appointed the sole arbitrator and take the decision in his favor. The question is, if the one arbitrator appointed by the one party and second arbitrator appointed by the another party, there are the mutually decided, there will be the two arbitrators appointed. Suppose if there is a conflict between these two, then how it can be resolved?
See, generally the clause in case of a panel arbitration,
Please.
as we all know that whatever Supreme Court pronounces a law of land applicable across the country. So if both parties appoint one, then the third has to be mutually appointed by both. And I will appoint you will appoint your, and they may definitely, there are scenarios, there are cases when both parties will not agree for a third one. Then again, we have to go to court only. I mean, then we can approach to High Court to appoint a third one. That's the only solution.
Please. No, the
There is
question
no
is,
point in, delaying, because we need to expedite the things. We need to close as fast in a time bound manner. So if this is a very practical problem, I mean, earlier what used to happen, even not only financial institutions, but even government, if you will do some business with the government will say our CMD, our so and so will be the sole arbitrator.
please.
So it's always better to have a panel if possible, and if both two arbiters are not able to decide on the third one, then again court, we have to go court. I mean, then court generally appoints the third one, and things can move further.
Please, thank you for the detailed discussions. Yes, anyone, please?
Hello.
Yes, please.
Sir, I have a question. Before the parties enter into a contract, sometimes parties doesn't directly do the contract. They sign a term sheet. These are the principal terms, whether it is binding on the parties or non-binding on the parties. Because sometimes the party doesn't want to directly contract with some other person, right? They agree on the key terms. So whether it is binding effect or non-binding effect on the parties. What's your views on this?
So as I told that contract is nothing but marriage of convenience, though when two parties come together to do certain business, to explore some business possibility. So this term sheet concept is generally happens when there are certain acquisition merger transactions. And term sheet is nothing but a principal understanding, which they say that will be captured in the final agreement or definitive agreement in detail. So there are judgment also of the courts, and it's a very settled law as well, that even if you have written, generally term sheet have a clause that it's a binding or non-binding, and the court has went to the extent of saying that this clause is not relevant. The intention of the parties to the term sheet has to be gathered from by going into all the clause or the entire term sheet. So intention of the parties matter, whether by their intention they want to make the term sheet binding or not. And to avoid sometime, how it's very difficult to gather the intention, the party prefer to mention in the term sheet itself. And as a legal guy, always try to mention, I mean, the time within which the definitive or the detailed agreement will be executed, term sheets will capture a line that it is the principal understanding between the parties, and the detailed contract or this thing will be entered in so much months or so many days from the date of executing this term. And always ensure that it is also clearly mentioned whether it's binding or not. So you are not leaving anything to the chance or to the interpretation and gathering of evidence from here and there. That is the best way of drafting. And ensure that within that period mentioned in the term sheet, the detailed agreement or definitive agreement is executed. If not, then get the term sheet extended. Or though theoretically I can say don't do business till definitive agreement is signed. That's very difficult to implement on the ground, because ground battle is altogether different. So generally parties start doing business also, but ensure that if that is there, make it binding, give it a time, ensure within time, or get it extended. So these are the various tools through which you can help your organization, company.
But as you have told, na, the parties have a prior understanding, or in that case, the party can sign the MOU also.
Nomenclature hardly matters. What you write, headings are only for convenience. It is the term sheet or the agreement. Term sheet is also agreement. If it is sufficiently capturing the intention.
Okay, sir.
Heading is of no consequence. Settled law. Substance of the document has to be seen.
Okay, thank you, sir.
Yes, Mr. Vivek, you want to ask something?
No, sir. No, sir.
Yes. Sir, one more questions that if it is both the party, what you have discussed about the neutral jurisdiction. Suppose one party is in Delhi, another party is in Bombay, and they want to go for the arbitration in Calcutta. Then it is a valid contract?
So, sir, what happens? There is a general law, there is specific law. If parties have agreed to a particular jurisdiction,
Please.
then that is valid. If they
Even though
have agreed to a jurisdiction only, then you have to see where law will come into picture, where the party have principal place of business, where director reside, and so on. Then these things will come into picture. Otherwise, if parties have agreed to a specific place as a where they will either court or arbitration, then that is hold good. It's a legally settled principle.
it's even though they are not residing, there is no place of business of any party.
Yes.
And even though any other place can be the valid jurisdictions, if it is parties are agreed in that contract.
I said in my presentation also, sir, with due respect, that
Yes, sir. That's why I'm discussing neutral jurisdictions you've discussed.
Contract is a marriage of convenience. हम जो भी mutually agree करके, so long essential of a contracts are there, like free consent, competency. If we are agree mutually on something, मियाँ बीवी राजी तो क्या करेगा काजी? That's like that situation. And that's why I'm saying कि भाई put everything in black and white in plain English. Don't leave any room for interpretation. हम नहीं लिखेंगे तो वो कहेगा जी यहाँ jurisdiction नहीं बनती. सबसे पहले question he will raise this court has no jurisdiction. आप तो sir you are well versed with all these things and you day in day out deal with court. उसमें एक point तो यही होता है ना कि भाई this court has no jurisdiction.
Please. This is the very first objections. Preliminary objections. The very first objection is taken by the most of the advocates.
Yeah.
Please, sir, please.
It's very well valid, sir. It's very well valid.
Thank you, thank you, thank you,
But
thank you,
when
sir.
there are
Thank you.
international contracts, what generally we do, we mention, just add on what to your query. We even select the law also. Okay, we will
Please.
govern by SIAC arbitration rule, or we will govern by UNICITRAL. Almost same, but still we prefer to mention.
Please, please, please. Thanks a lot for all those detailed discussions. Anyone else, please? Otherwise, time is over. Sir has given their very valuable time, 1 hour.
My pleasure, sir. I'm always here. If I can contribute to whatever we have learned over period of time through our experience and, with the company of all you people, if we can give something to the next generation, pass on. I'm available on email also if someone have any specific query. I'll try my best to address if anyone has any question. You can circulate my email ID. I'm not into practice. I'm fully employed with the
Please,
organization.
sir, please. We have a depth knowledge of the subject matter. Yes. Then if there is no question, then we will wind up. Yes, Miss Suyas. Is there any questions? No. Yes, Miss Suyas, go ahead.
Thank you, sir. Am I completely audible and visible to you all?
Yes, yes,
Yes.
yes.
Thank you, sir. Well, that was very informative session, and I'm sure you all must have learned something. I extend my heartfelt gratitude to Mr. Krishna Kumar for delivering an insightful knowledge on contract drafting. His expertise in the field has undoubtedly enriched our understanding of his critical aspect of legal practice. Sir, comprehensive presentation shed light on why contract is important, emphasizing the importance of clarity, correctness, and adherence to the legal variation. His in-depth exploration of key principles such as consideration, offer, acceptance, definition, interpretation, scope of work, IPR and confidentiality, legal requirement of a valid contract, and many more things has provided valuable insight for the professional and legal domain. We appreciate Sir adherence to sharing his knowledge and expertise, making this webinar a valuable resource for all participants. And sir, we are really sorry for the technical issues and all the inconvenience caused. And at last, I also thanks Vidya Vijay Foundation and Nityanand sir for organizing this informative session. And thank you so much, sir, for your time, expertise, and the commitment to enrich our understanding of contract drafting. It was really a very informative session for all of us. Thank you so much, sir, and thank you to all the participants for this presence and the valuable questions. Thank you so much.
थैंक यू किशन जी, बहुत बहुत धन्यवाद आपका। आपने हमें बड़ा अपना कीमती समय दिया, बहुत बहुत धन्यवाद। और हमारे सभी साथियों का धन्यवाद जो हमारे साथ यहाँ पे जो है ज्वाइन किए। फिर हम नेक्स्ट यू यूज्ड टू हैव ए सेशन ऑन द 2nd and 4th Saturday, तो जो अगला हमारा
टॉपिक इज रिलेवेंट टू मी, आई एम ऑलवेज देयर सर।
Please, I always most welcome to you.
Saturday is off. We are a 5-day working company, so Saturday, Sunday we can plan.
Sir, it's our great pleasure to have a experienced person like you.
Thank you, Vidya.
And we have a session on the 2nd and 4th Saturday every month. Then next session would be on the 10th of February, but that will be our anniversary as well. Then Constitution Club of India, our next session would be on the Constitution Club of India, and all our the learned friends who are present here, all are the invited in the Constitution Club. Thank you.
That's great. Thank you, Ji. Thank you.
Thank you.
Please, sir, thank you so much, sir.
Dear participant, please switch on your video so we can take a snap.
Please.
Switch on your videos, please. You have some beautiful faces. Without switch on the camera, we cannot see it.
Thanks a lot.
Thank you, sir. बहुत बहुत धन्यवाद. Namaskar.
Thank you, Ji.
Everyone, thank you.